My name is Isaac Bishay. I'm a research assistant with EuroExpert and a PhD researcher at the Sorbonne under the direction of Professor Livia Holden. This event is the policy launch for EuroExpert and marks us entering the final phase of this project. EuroExpert, or Cultural Expertise in Europe, what is it useful for, has been studying the use and impact of cultural expertise in 16 European countries with spin-out projects from India, Pakistan, and Indonesia. EuroExpert is funded by the European Research Council's Consolidator Grant and is led by Professor Livia Holden, our principal investigator, who has also been awarded the Proof of Concept Grant for Cultexp, the first multilingual and cross-jurisdictional database for cultural expertise. Over the course of the project, our team, Dr. Noora Arajärvi and Professor Holden, with the assistance of Anyungo Tuminasan, have been hard at work at building the EuroExpert policy, which outlines the ethical and inclusive adoption of cultural expertise. The aim of such a policy is to assist policymakers and stakeholders with a roadmap for the adoption of cultural expertise. We are honored to have a diverse pool of very experienced and interdisciplinary discussants. Their contributions reflect the specialization and the thematic engagement with EuroExpert. Judges Civinini and Wiersinga, who have worked with EuroExpert since the first steps of the project, including the indicators of impact and the development of teaching and training modules. Judge Macleod and Professor Rohe, who have contributed with publication and commented in depth on the policy document. Ms. Ghazi and Dr. Pilatovsky, who are crucial stakeholders for the policy adoption and dissemination and have both played a pivotal role in data collection and the elaboration of policy writing. This event will last about 1 hour and 30 minutes. After Professor Holden briefly introduces the project, Dr. Arajärvi will present the EuroExpert policy and its related themes and implications. Afterwards, our 6 discussants will share their comments and advice for about 7 minutes each, and afterwards we'll have 20 minutes of questions and answers. It is now with great pleasure I invite Professor Holden, our principal investigator, to present our research project.
Thank you, Joshua, and many thanks to the discussants as well as the audience who have joined us today for the EuroExpert policy launch. Joshua has already mentioned the main focus of EuroExpert, which is the role and impact of cultural expertise as an umbrella concept for all the instruments that include the use of cultural arguments and social legal knowledge for the resolution of conflict and the ascertainment of rights. In the course of the implementation of EuroExpert, we have worked closely with the members of the legal professions and with the relevant stakeholders in the 16 countries of the research. And today, we are honored to have some among those who have been very active interlocutors and contributors to the action of EuroExpert. As a ERC project, EuroExpert carries out frontier research, and this means that the core of our action has been to elaborate the theoretical and ethical framework of cultural expertise, to collect qualitative and quantitative data, and to envision criteria to assess the frequency and the impact of cultural expertise. And the general finding is that the umbrella concept of cultural expertise makes sense for the one who think that the understanding of cultural and social background of facts supports a more inclusive justice. In fact, cultural expertise covers as a theoretical framework the great variety of instruments that we have surveyed in the 16 countries of the ERC research, plus Pakistan, India, Indonesian as spin-out projects. And in all the research sites that we have explored, where we have collected data, the demand of our stakeholders has been training, capacity building, and policy making. And for this reason, we have engaged perhaps even more in depth than initially foreseen with answering the demand of our stakeholders and research participants to elaborate on policy guidelines. And as Noora will explain later, our policy guidelines are flexible and beneficiary-led. We advise to empower the stakeholder of cultural expertise and choose which aspects of the guideline are the most appropriate to each specific context. Dr. Arajärvi who has worked with Euroexpert first as data collector for Finland and then as postdoctoral fellow, has taken up the lead of the policy task in 2021. She received her PhD from the European University Institute and has conducted research as postdoctoral fellow with the Berlin Potsdam Research Group, the International Rule of Law. She has held teaching positions at the UCL Cyprus and University of West Indies. She has been visiting fellow at the Max Planck Institute and Fordham University. She also worked at the UN Rule of Law Unit in New York. She's also a published author. She has published The Changing Nature of Customary International Law, published with Routledge in 2014. She has also co-edited a collected volume, and she is also authored the chapter on cultural expertise in international human rights law in our upcoming volume, Cultural Expertise, Law and Rights. Noora at Euroexpert is responsible for the scientific coordination of consultant, the formulation of guidelines for the treatment of personal data and legal documents, and the development of the policy that we are launching today. For the policy, Dr. Arajärvi has painstakingly reviewed all the data that we have collected. She has compared the legislation in all the countries of the research. She has conducted targeted interviews with our stakeholders. And the result are two documents which propose an actionable roadmap for the adoption of cultural expertise. Today, we launch these two documents, and we will ask the discussant to share their thoughts and idea for further dissemination. This event is a continuation of our work as researchers in the cross-sectoral and interdisciplinary styles that we have adopted as methodology from the very beginning of the action. So I will now invite Dr. Arajärvi to tell us more about these two documents.
Thank you very much, Livia, for the introduction, and Joshua for coordinating this event and for many years of collaboration we have had. I also want to extend my thanks to the discussants. I'm very glad that you accepted the invitation to join us, and especially also for those who have provided comments on the policy drafts. I will now present our policy document, starting with its premise that Livia already touched upon, namely the demand of our stakeholders and research participants for a guide on policy making. And I will explain the target audience of this document. I'll also give an outline of the type of data we have used, what the document is based on. Finally, I will go through each of the 6 milestones and how they can be achieved and implemented. And as Livia mentioned, we have 2 versions of the document. So we have this 14-page policy document that you have received, as well as the 1-pager that contains the milestones and some basic information. But I will say a few words about that at the very end. So why have we drafted this policy document, and what can it do? Advancing the awareness on the appointment and the use of cultural expertise is relevant across different policy fields, and therefore it can be integrated into policymaking, not only as a highly specialized subject, but as a cross-cutting feature in different areas. With strong empirical data backing up this proposal, it anchors its aims in the proven needs and calls for cultural expertise to clarify what it is, how it can be accessed, and how it can be used. This document presents potential procedural and substantive policy choices that are found and analyzed from comparative as well as novel and conceptual sources. So who is meant to read this policy? This policy document is addressed really to anyone and everyone who might be interested in cultural expertise and how it can be ethically and inclusively adopted and used. However, its primary audience are the stakeholders who are involved in policymaking as governmental and non-governmental actors and groups that are affected by or can benefit from cultural expertise. The document also has given us the opportunity to report back on the stakeholders' engagement with Euro experts, data collection and consultations, especially drawing from the examples of appointments of experts, type cases, and tools for formulating and implementing policies on cultural expertise. State actors can use this policy to gain an overview of the modes of appointment and typical cases that involve cultural expertise, either in their own countries or reflect on the practices from other countries. National parliamentary and governmental debates that concern improving access to justice and social inclusion in the judicial process can integrate some of the data on the frequency and variety of the instruments that fall within the umbrella concept of cultural expertise. State actors will also benefit from our action-oriented approach in this policy. And these range from legislative reforms to awareness raising and training of judges, lawyers, and experts, which I will explain under one of the milestones in more detail. This policy is, of course, also addressed to judges at all levels and within all types of jurisdictions, because our findings show that various instruments of cultural expertise, even if they are not actually called that, are already part of the everyday practices of judges and courts in many jurisdictions. By reading this policy, members of judiciary can enrich their knowledge of procedural aspects of instructing experts, assessing advantages and disadvantages of cultural expertise to their decision-making, and gaining a deeper understanding of the variety of cases that do involve cultural expertise, whether explicitly or implicitly. And finally, this can encourage transnational judicial dialogue among judges and lawyers from different countries. In addition to state actors, non-state actors that we have identified and we are addressing within this policy include associations of lawyers and judges, expert associations, NGOs for refugees, asylum seekers, all types of social minorities and vulnerable groups, as well as non-state actors working with human rights cases and other interest groups. Experts and expert networks, such as associations of country experts and professional associations, will find in this policy descriptions of law, policy, and practice that illustrate the entry points that they can also use within legal processes for cultural expertise. And finally, lawyers and attorneys will benefit from this policy in several ways, with the overview of legislation and policies in 16 European countries, will add to their knowledge of their own system, as well as the comparative aspect, very similar to, as I described, for judges. But also the foreign precedents could provide for cross-fertilization between legal systems and develop procedural and substantive law. Now, what is the basis of this policy document? What are we drawing from? It is an evidence-based output of the project, and it's compiled using a broad variety of data collected by EuroExpert over the past several years. I will give a short description of the data that we have used within this document. So we have run surveys in all of the EuroExpert countries, collecting views and data from judges, lawyers, experts, and beneficiaries on types of cases, types of experts used, and how they have perceived cultural expertise, its usefulness, accessibility, and so on. We have used a very broad bulk of case court decisions that have been collected in Euro-expert countries that link in one way or another to cultural expertise. And these cases have been collected by several country consultants over the years, and they are also included in our database. And they really show the variety of cases where cultural expertise is being used. Similarly, we have used expert reports that link often to these cases to see how expert reports are formulated, what aspects they address, and how, if there is a link on how judges then use those expert reports. We also have out-of-court data, which means the sites where cultural expertise is used outside of the courtroom. Often this could be prisons, hospitals, refugee centers, and so on. And we have mapped this also with the help of country consultants. We've had many interviews, and I thank those of you in the present event who have contributed to this. That has been very helpful in checking our qualitative and quantitative data through the semi-structured interviews with professionals. We've also done some workshops, filming and training. And then as one of the final data collection activities before actual drafting of the policy, we compiled all relevant legislation, regulations, policies, registers, and any other data relevant to the appointment of experts from these 16 countries. And this has been extremely useful in identifying the similarities and differences on expert appointments, as well as potential gaps and challenges which this policy document then aims to address. What is in the policy then? Now, first, the policy explains the concepts. What is cultural expertise? Who are cultural experts, and where is this expertise used? How useful is it? And it provides some conceptualization and context to these questions. It then describes, using the data, how to identify or find experts and how to appoint one. Now, we spend a lot of time thinking what our data tells us and how to describe the ethics of cultural expertise. This is one of the so-called red threads or cross-cutting features within the policy document and within the 6 milestones. It relates to the role of experts, how they can advance equality and systematic inclusivity, but noting that sometimes these intentions and interventions may translate differently to different audiences and different groups. And there are risks involved, such as essentialization of cultures and stigmatization of vulnerable communities. The professionalization of cultural competence supports also ethical awareness. The data collected by Euro-expert shows support for the creation of a shared ethical guide to assist experts in the practice of their profession. This is included under one of the milestones as well. Another element of ethics concerns the independence of an expert, which also then links again to professionalization and integrity, awareness as well as training, so that judges and parties can truly appreciate that experts are presenting evidence-based and independent reports. And the experts understand their responsibilities to the court, to the parties, to vulnerable groups, and to their professional community. Now, our roadmap of cultural expertise includes 6 milestones, which are identifiable with the acronym AAIIDD. That stands for Awareness, Access, Implementation and Innovation, Integrity, Development, and Digitalization. Each milestone includes a description of what it is and how it can be achieved. This is followed by more precise points for policymakers to consider, which are framed as questions. Finally, each milestone presents practical steps towards reaching it. Now, you will see that in addition to the ethics of cultural expertise, there are some other cross-cutting features included in the steps to reach different milestones. This is not a duplication, but it shows the importance of certain elements such as lists of experts, remuneration of experts, and training, how relevant they are for the policy roadmap as a whole. So, our first milestone, awareness of cultural expertise and cultural experts, entails that there are effective policies and practices in place to support the identification, appointment, and remuneration of cultural experts. It speaks not only to policymakers, but also to judges, lawyers, and experts themselves. Awareness is needed on the necessity, benefits, and potential pitfalls of cultural expertise, and knowledge on how to use cultural expertise in courtrooms. Reaching this milestone requires the engagement of judicial actors, key stakeholders, the civil society, and professional expert associations. This milestone also includes awareness of cultural expertise in out-of-court conflict resolution, which can reduce the overall legal costs and the time needed to solve disputes without reaching the courtrooms. To support this, on our website, we have mapped existing out-of-court sites, as I already briefly mentioned, which can be useful for stakeholders. So, while awareness of cultural expertise is crucial, to actually use and benefit from such expertise requires access to experts. This is our second milestone in the roadmap. So, how to access experts? Registers and certification can be very helpful for judges, lawyers, and parties to identify and contact experts. Our data shows that several countries do in fact have registers or listings for cultural experts, varying from open access registers to controlled registers, which are endorsed by professional bodies, and those that are maintained by the courts themselves, which may be court-specific, regional, or national. Such registers or listings, however, should be inclusive and transparent, and they should be revised periodically to foster the inclusion of junior experts and to make sure that those who belong to social, linguistic, ethnic, and religious minorities are included. Another important element in accessing high-quality expert evidence concerns the rates, again, of remuneration, which should be clearly defined and openly available, and ideally included as part of legal aid. Next, to promote and improve access to cultural expertise, it is essential to have legislation, instruments, and resources, as well as established policies and practices on the appointment of experts, leading to our third milestone, namely the implementation and innovation of existing laws. Although the level of detail and clarity of legislation on the appointment and role of cultural experts varies greatly between countries, in nearly all Euro expert countries, such legislation is already in place. But it can be improved further or implemented more effectively and supported by regulatory and policy tools. Therefore, this third milestone calls for policymakers to review existing legislation, instruments, and resources with a view of creating a balance between flexibility and predictability in the appointment of experts. This includes a broad mandate to appoint experts, meaning both the judge and the parties could do this, and flexibility in the formal credentials and other attributes that are required from the experts. For instance, not limiting the appointments to only those experts who are nationals of the country in question. How then experts conduct their work ethically and engage with courts professionally? This is covered by our fourth milestone, integrity of experts and ethics of cultural expertise. This is something I already touched upon, and I will simply say that we noticed through our qualitative data collection and interviews that more open dialogue is needed on the benefits and risks of certification and oversight mechanisms of experts. The certification process should, however, ensure diversity in a very similar way to the registers, and make sure that cultural expertise stays true to its ethical framework and professional integrity. Our fifth milestone then addresses the development of skills on cultural expertise. And this covers many aspects, from training of judges and lawyers, building networks and cooperation between legal professional and cultural experts, to training of cultural experts themselves on how they can increase the knowledge of legal procedure and how to best present their expertise in a legal setting. Some practical steps that we have suggested include inviting cultural experts to intern in courtrooms, introducing shared tools to make the work of cultural expert more technical, if you like, so it can be recognized as useful and objective by the courts and stakeholders. Finally, our sixth milestone is the digitalization for sharing knowledge of cultural expertise. This proposes measures to foster and deepen the dialogue between political representatives, policymakers, stakeholders, and experts to create a real space for awareness training and cooperation. Digitalization as milestone also connects and supports the other 5 milestones. Now, at EuroExpert, we have built the Caltex database, which policymakers and others can benefit from, accessing online around 4,800 cases and expert reports. In addition, KExp is a digital tool built to support Caltex, which includes an open access register of experts. So this is a short summary of the 6 milestones that we have included in our policy. How to use the policy then? And Tosha, I'm nearly at the end, so I will need less than 60 seconds. Each milestone is intended to have both an independent and an interconnected role, and they can serve either as a starting point, be set aside, or further developed and adapted by the users, depending on the context and the country situation. With an understanding of cultural expertise and its usefulness, stakeholders and policymakers can review the situation they want to address in more depth and experiment to find the optimal entry points and the optimal instruments within these milestones to fit their policymaking process and implementation measures. So, as I said in the beginning, we have 2 documents, and this one-page document that's also available on the website, we are currently translating into French, Italian, German, Polish, and Spanish to reach a wider audience. So I will now thank you for your attention and give the floor first to Joshua to introduce the discussants, and I very much look forward to your reflections on our policy document. Thank you.
Thank you very much, Dr. Noora Arajärvi. It is my pleasure now to invite our first discussant, Judge Civinini. Judge Maria Giuliana Civinini has been a member of the judiciary since 1983. She started as a judge in the Tribunal of Modena, and then she was elevated to the Supreme Court of Cassation in 1999. In 2002, she became a member of the High Council for the Judiciary and was later appointed as president of the Assembly of ULEX judges for the CSDP mission ULEX Kosovo. She was president of the Civil and Labor Chamber of the Tribunal of Livorno, president of the Criminal Chamber of the Tribunal of Livorno, and president of the Tribunal of Livorno, and later a co-agent of the Italian government in front of the European Court of Human Rights. Since August 2019, she's the president of the Tribunal of Pisa. Since 1993, Judge Civinini has been actively involved in judicial training in substantive and procedural laws. As an expert, she assisted the Consultative Council of European Judges and cooperated with the OSCE, EJTN, IPA, Twinning Projects, and TIEX in training and support actions. Since 2020, she has been the president of the CPEJ Cyberjust WG Working Group. Judge Civinini has been very engaged in women's rights and in defending the independence of the judiciary. Finally, Judge Civinini has recently published an article with us entitled Cultural Expertise in Civil Proceedings in Italy as part of the special issue of the Nordic Journal of Law and Social Research entitled Cultural Expertise and the Legal Professions. It is now my pleasure to offer the floor to Judge Civinini.
Thank you very much, Joshua. Good afternoon, everyone. I'm very pleased to be here with you in this very interesting launch of your policy. I have to congratulate the whole team and especially Noora because it's really a very effective tools for implementing cultural expertise in our countries. We were invited to pick up the two most important milestone in our opinion. I have to say, but Noora already stressed it, that they are all interconnected. But if I have to choose, in my opinion, the most important is awareness on one side and digitalization on the other. Why? In court, we have a huge need of cultural expertise, but generally speaking, we are not aware of this need sometimes, and we are not aware how to introduce this cultural expertise in trial and in court generally. We started recently in my tribunal to discuss the creation of an informal registry of cultural expert and cultural mediator. And we had the very important advice of Livia in dealing with this. And discussing with the colleagues, it was clear that at the beginning, all the judges were wondering what is and how can I use it? And once understood the meaning and the implication, everybody started to find example in their own experience of a situation in which if they would have a cultural expert in the trial, the management, the treatment of the case would be much better. On the other side, digitalization is very important because, as you said, in the guideline in the policy, to share knowledge, to share documents that are often difficult to find is crucial. And I would add another element. The COVID-19 pandemic has shown that only judicial system who are provided with strong digitalization and e-filing and the telematic trial has been able to deliver justice to citizens even in this difficult situation. And case management system, intelligent case management system, and new tools for hearings have been developed and now are in use everywhere, more or less everywhere. Then I think that because to find the right cultural expert can be not so easy, and often they are not living in the area where the trial has to be held, and sometimes they are not even in the same country, and it would be too much expensive, clearly, to have the right expert in court, then to use and to spread the use of video conference for for expert and for deliver expertise, for allowing exchange between the parties, the lawyer, the judge, and the expert, I think will be crucial, and this could need some additional guidelines to be sure that the means are in compliance with the human right and procedural human right requirement. I will tell you some word on how I would like to disseminate your policy. As I said, we had already a call for contribution for expert and mediator. We are building a register of experts for our court that will be open to continuous revision, and it will be on the website, including the list of the expert, the CV, but also how many times they are involved in trial in view of transparency of our action. And we wanted to organize an awareness raising event, tentatively in coincidence with the European Day of Justice of 55, that generally is on the 25th of October. And in this event, we would like to address the issue that are listed in the policy paper under the milestone awareness, but also to illustrate the policy itself, the policy and the milestone for themselves, and the country data gathered by cultural experts. This data shown that in my country, for example, cultural expertise has been used mostly in the area of asylum and immigration law, mostly on the initiative of lawyer or refugee center. And so again, the lack of awareness of judges in using this tool come out, and it needs to be addressed. And as a following step, a more specific training for who will in our register, and hopefully they will be many. Last, we are building in Italy in general, but I'm working in my court to a case law database that is with the fund of the recovery fund, and we are collecting all decisions. We want to put them in open source, and we are building some search engine that should use artificial intelligence, or at least some simple algorithm. And one section of the database could be dedicated or having a specific search engine for individuate the cases in which cultural expertise need raised and how it was addressed. And for the moment, it's all. Thank you very much.
Thank you very much, Judge Civinini, for that presentation. Our next discussant is Judge Firsenka. Judge Hermine Firsenka has studied and worked at the law faculty in Leiden. Her dissertation focused on processing cultural data in the field of criminal law. She's worked as a judge at the Tribunal of Rotterdam and at the Court of Appeal in The Hague. During her career as a judge, she has dealt with several cases in the international field, including terrorism and its financing. Currently, she's on the chair of the Innovation Chamber. She's worked to eliminate the backlog, most of which concerns about cases of hard drugs, money laundering, and corruption and undermining. The Innovation Chamber tried to be creative with procedures and process agreements between defendants and prosecutors in an open, transparent, and communicative way. Judge Wiersinga is also active in research about the boundaries of law and procedures in the sociocultural context. Finally, Judge Wiersinga recently published an article with us also entitled The Judge and the Anthropologist, Cultural Expertise in Dutch Courts, as part of the special issue of the Nordic Journal of Law and Social Research entitled Cultural Expertise in the Legal Professions. I now give the floor to Judge Wiersinga.
Is this all right? Can you hear me?
We can hear you just fine. Thank you.
Okay. Hello, everybody. Hello, the discussants, and especially the core participants. Congratulations with this wonderful result. I see a lot of hard and inspired work has been done very well. And very good that you did succeed in, as we all know, a difficult time with, well, COVID and so on. I have some small remarks, and I do hope that they are supportive for the project. And I'm happy, of course, that I'm privileged to join this discussion. Well, first thing, my overall impressions. To me, it seems that you covered, well, almost all the relevant themes and problems, and also some niches and very important details. I could only think about one thing, and that is something maybe you cannot address at all, but it might be important in practice, and that is the financial thing. Because I was wondering, I don't know, I hear complaints here in the Netherlands about, you know, the behavioral scientists, for example, they have very high costs and low money out of advising the courts. I don't know exactly how we can address it, but it seems to me an important thing. Well, maybe that's something for, well, in the future. By the way, I remarked that the Netherlands were also a niche because they were not, I think, because of our own fault, not responding enough to invitations to participate and answering questions. And they are not in the data summaries, but I hope they will be there in the future. Well, about the document, it's very important that you started with the accent on respect for diversity. It is in the first sentence, and we should repeat this and frappe toujours, because you have to get people to appeal on their responsibilities in this. And Noora spoke about systematic inclusivity. Well, it cannot be said enough. It sounds maybe a bit hollow, but it's very important that we do realize here in the Netherlands, we have lots of things like ethnical profilation, for example, and big scandals about how people were not inclusive in society, but excluded and just suffered from it. And it's really a big thing now in the Netherlands. I will not explain on that very much, but it is an important thing politically also. Well, I do like the practical approach very much in this whole project. And how else could it be possible to realize something when you see all those borders and all those countries? But still, of course, the content is almost about everything. And that's sometimes a bit difficult for me, at least, because I'm just a judge. I will focus on my group, the judges, and on criminal law, though I'm curious about certain, for me, quite unfamiliar fields mentioned here. I cannot wait to go into the data bank and to see what else I can read on cases and so on, because it's, of course, for a curious person, and every judge should be very curious, a gold mine, so to speak. Well, in criminal law, you can find lots of what I call ad hoc cultural things and issues. And it's good, just as an example about what also is well, some scandalous thing here in the Netherlands, is that you can never trust in common sense. I thought that the interpreters and the translators were sort of accepted, that is, their role is accepted, it's important that they are here. But even in this domain, sort of hardware for the cultural expertise, for cultural information, you see that that there are problems. They had a strike. It was a big issue. This group is underpaid and not respected too much, and it gave big problems. And I was shocked about that how problematic it turned out to be, to give openly support also from the judges, that everybody was sort of holding back and saying, well, oh well, yes, maybe. I was disappointed about that. And everybody knows how extremely important they are. But well, this whole thing lowered my expectations about success and use of also this marvelous project in the short term. I think in the long term, it will come, but there is a lot to do about mental resetting, so to speak. Well, I myself am sure that there is a lot of added value in cultural expertise, and those insights will come, but it will take a lot of time, I'm afraid. And of course, there's no one-size-fits-all guide, as you say. And then I come at the milestones. I was, I saw that the first speaker had the same milestones as I did, awareness and digitalization. And it has been said also, all those domains are, of course, the milestones, of course, are connected with each other. And you see that, well, for me, awareness was, so to speak, the first step to almost everything else. And what you especially have to do is to bring up those issues in the institutions that do permanent education. Judges here in the Netherlands also have one institute that gives courses and do trainings and so on for judges and also for prosecutors and even lawyers sometimes. And there is also an institute for behavioral scientists, also very important. And that's the place where you should start, I think. And of course, this is related to milestone 4 about the integrity of experts and the ethics of cultural expertise and the development of, oh, I said it, and that's 5, the development of cultural expertise. Well, number 6, digitalization, is of course also very important. I am impressed by the enormous amount of work on this field already done. As Noora said, it supports all the other milestones and it's substantial, it's concrete, it's something you can work with and you can work on. I know, well, judges are, at least in my opinion, not always too digit smart, and they are also a bit spoiled because everything is done for them and they get help with everything on the floor. So what they need is a very easy handout and access to all those data. I think once they are in, they will explore the possibilities by themselves, and I'm convinced about that they will be curious, they are wanting to know what's in it.
Thank you very much. Very sorry, but
Thank
it was
you.
very interesting. But we have to introduce our next discussant right now. Dr. McCloud. Judge Dr. Victoria McCloud sits in London as a Queen's Bench Master in the High Court and was the youngest and only second woman to have been appointed. She is a chartered psychologist, a senior associate research fellow at the Institute of Advanced Legal Studies, and an associate fellow at the Global Network on Extremism and Terror, Department of War Studies, King's. She's an expert advisor to the All-Party Parliamentary Group on AI, an expert on the Royal College of Psychiatrists Working Group on Historic Child Abuse, and one of 12 nominated whistleblowing judges appointed in the UK. Her publications include the Surveillance and Intelligence Law Handbook, Civil Procedure Titles of Papers, and a short book on poetry. She was one of the Sunday Times 50 Women of the Year in 2020, and she's one of 100 selected role model women lawyers spanning the first century since women were permitted to practice law in the UK. I now give the floor to Judge Victoria McCloud.
Thanks very much, Joshua, and thanks to Livia and to Noora and everyone for inviting me and for involving me. It's been a great pleasure. And what a high impact project it is. You only have to look at the outputs page on the website to see just how much material has been produced arising from this, not just this key part of the project that's being launched today, but all the stuff that's gone before. It's really quite huge. I also want to just say hello to Judge Call QC, who I saw in the list of attendees. I'm very glad to see her here. It's a public holiday over here. She's the head of the Judicial Support Network, and it's really great to see a senior judge like her here and tuning in and showing an interest. And that perhaps is part of the process of raising awareness that my judicial colleagues have already spoken about. I've been asked to give my overall impressions to start with. I think what's really important about this policy document is that it's accessible. It's written in language which isn't going to immediately put off the reader, if you like. If it was written in socio-legal speak too much, then those that we need to address with these sorts of issues perhaps might be put off. I think it's also of an appropriate length and clearly structured, which I think is really important. What I would suggest, I don't know if maybe it's been done already, but of course it needs to be made translated into other EU languages and also perhaps made digitally available in accessible formats in terms of people who are visually impaired, perhaps, so that we can make sure that we widen that access. Now, I'm well known to be, pretty passionate about all things cultural, but cultural expertise in this context. And I think that substantive justice obviously demands that we take that on board, perhaps more than we do. The principal area in the UK where you see it would be immigration and perhaps sometimes in crime. So I think the milestone, I'm going to be boring, like my colleagues picked the same. For me, I was only asked to pick one milestone, and I think it has to be awareness, looking at it from a judicial point of view. There's plenty of awareness over here in the UK about the need to be sensitive or whatever, and there's a certain amount of guidance, but actually elevating that to a point where judges are actually aware that there is such a thing as cultural expertise, I think is not off the ground other than in the sort of immigration and asylum areas. Now, how do we go about raising that awareness? Because as part of being invited, I was asked to say, well, what could we actually do? Well, there's a judicial college in the UK. They do training, awareness by them of the database, for example, awareness of cultural expertise as a subject could be quite important. They could feed that in potentially into training materials for judges, because as I think one of my previous colleagues commented, that the database is a goldmine, and judges ought to be aware of it simply through their training process. And that's a kind of nil cost option, really. There's also the Equal Treatment Bench book in the United Kingdom. I gave a talk about that actually to this group about a year ago, because I played a role in producing the last edition. And that provides a lot of links and to resources of relevance to how to conduct hearings fairly in a general sense, not just culturally, but also including culturally. And I think it's really probably important to make sure that the outputs from this project and this policy and the database are drawn to their attention. There are also diversity and community relations judges in the UK who are judges who have a certain amount of responsibility for promoting diversity and inclusion in the areas in which they work, and perhaps making them aware would be useful. In terms of wider awareness with the actual legislators, it could the outputs could be made aware, for example, to the Lord Chancellor, who is the political head of the judiciary. He doesn't make decisions in a judicial sense, but he's the government minister in charge of the department, the Ministry of Justice, and perhaps his shadow, Mr. Stephen Reed, who is the opposition equivalent, so that whichever government one has in the UK, and it tends to switch between two, they're aware of that from a policy making point of view when it comes to things like legal aid, when it comes to things like legislation around court rules, which at the moment do limit experts fairly tightly. I think there are other areas where this can be of great use, in areas which are slightly counterintuitive, actually, which occurred to me while I was taking notes from what my colleagues said. For example, actually within the judiciary itself, we have things like grievance processes, for example, where maybe a senior judge has treated a junior judge badly and there's a complaint. And it might be said actually that there are cultural factors in play there. Because we have quite a diverse judiciary, but often one tends to find that the senior judges, it's a cliche, but the more senior the judge, that if you like, the whiter and more male they get, as well as older. That's just the statistics. Actually, cultural awareness in that internal context, when it comes to grievances, could be important. Likewise, in recruitment, we have processes of recruitment in our country which are that involve a certain amount of consultation within the judiciary among senior judges about potential applicants for promotion. And where you have someone from one culture working alongside a more junior judge in a local court, it's important that people involved in that process are actually aware of cultural expectations, for example, around Muslim women and alcohol and socializing with their male colleagues in a way that might actually count against them if the judge is less aware of those cultural norms when one is talking about a consultation process. Lastly, out-of-court mediation, dispute resolution, quite important, I think, to perhaps make sure that those involved in those processes and the associations and groups that actually train mediators are aware of the database and the policy. Lastly, I just need to conclude, because a judge got into a spot of bother fairly recently. I just want to make it clear that everything I say is in my academic and personal capacity and not officially on behalf of the judiciary, since I know this will be published. And I just want to make that clear. Thanks very much. You see, I set an alarm.
Thank you very much, Judge McCloud. Now for our next discussant is Professor Mathias Rohe. Professor Dr. Mathias Rohe was appointed full professor for civil law, private international law, and comparative law at the University of Erlangen-Nuremberg, where in 2008 he founded the Erlangen Center for Islam and Law in Europe. He has served as a judge in the Court of Appeals, Nuremberg, from 2001 to 2007. Professor Rohe has published intensely on Islamic law and on the development of Islam in Europe. For example, Islamic Law in Past and Present, published in Leiden in 2015. He regularly advises the German European governments and administrations, including issues of cooperation between state and religious communities. He's elected member of the Academy of Comparative Law and of the Bavarian Academy of Science. In 2020, he was awarded the annual prize of the German Scientific Association of Islamic Theology for his merits regarding implementation of this subject in German universities. Professor Rohe was engaged in interreligious dialogue in Germany for the last 30 years. He has continuously participated in German Islam Conference established by the Federal Ministry of the Interior since 2006, and is an advisory board member of several organizations involved in interreligious dialogue. I now give the floor for discussion.
Thank you very much for the kind introduction. Thank you, Livia, and the whole team for enabling me to share some thoughts on your tremendous work you did. It's really, it's timely, and it's so clear and concrete that I'm sure it will have a strong impact. I don't know whether I should be released or concerned that seemingly we have the same kind of obstacles to be overcome in several European countries. So I will also start with the topic of awareness and add digitalization. Maybe these are the two crucial points. In my country, which is Germany, we do not have any kind of formal specific implementation of cultural expertise in our courts or administrations. Of course, the persons involved might resort to all kinds of expertise, but it depends very much on the personality. And we have two obstacles. One obstacle is time constraint. So implementing cultural expertise means it takes a certain period of time to listen to the expert, to review the information, etc., which might be in conflict with, let's say, some very tight agendas, especially in lower courts. And the second point is payment. I think Judge Wiersinga already mentioned that this kind of expertise is not very well paid, at least in my country. So it's not encouraged to become an expert in this field. For sure, this goes beyond your project, but I think if you contact relevant stakeholders, you should also mention this financial dimension of all these things. I had interviews with interpreters, for example, who told me the time they invest is extremely badly paid. So we do have a lack of finance there still. There is an urgent need of information. In many courts, we know that from a European project, Religare, we run 10 years ago, we had European judges conferences, and all the same kind of, let's say, complaints or at least the wish to get more information about legal institutions of other countries within their social environment. So some people might have an idea, for example, about Egyptian law or Malaysian law regarding marriage or inheritance, but they have no idea about the social function of these legal institutions, which might change in the course of the change of residence of people involved. So if you have a dower provision, for example, in a matrimonial contract concluded in Iran, its function might tremendously change if this couple lives in Germany, if this dower provision was meant to give the wife a bargaining tool for, let's say, quarrels, for example, about the custody over children after a divorce, which has no sense anymore if this couple is living in Germany, because there we do have a totally different regime of custody over children as compared to Iran. So this kind of background information, the link between the legal institutions and their social function. And second, culture of communication. So if you have people which are socialized in a culture of shame rather than in a culture of guilt, they will start explaining the whole topic by starting with the grandparents. And if the judge, due to time constraints, would say, well, please come to the topic now, people think, well, we are already dealing with the topic, but if you silence them down by this idea of please be very much to the point, people feel to be not heard, to be not understood. They would lose their trust in our institutions, and that's what we have to contravene and to make them heard. And we do have the urgent need of, let's say, some more self-reflection then on our benches. I mean, there are many people who have this idea, we should get more information, but at least in Germany, there is a number of judges, I think, who think that given their experience in daily life, given their legal education, they can tackle all these conflicts, and they are not aware of this kind of unconscious biases we do have regarding, for example, what is a family? Is it the core family? Could it be the extended family? What about the relations within the extended family? Do they count before the law or not? So we have to really raise awareness regarding these points, and we have to start with it in legal education, in our university studies, which is very much underdeveloped in my country. So the ideas of law and might be much more taught in US universities, etc. But so far not in my country, unfortunately. I think it makes a lot of sense to contact the relevant institutions, the relevant associations, at least in Germany. I think there is a lot of goodwill, but they should be more aware of the fact that we urgently need this kind of cultural expertise to make our system efficient, to reach out to everyone living in our country. So we have the conference of ministers of justice in Germany. We do have 17 ministries of justice, 1 federal and 16 state ministries. So this could be an addressee. In addition, lawyers and judges associations and our academies for judicial training. And so I could only encourage to contact these institutions for making them aware of this tremendous project. One last point, maybe, it was already mentioned, ADR. We do have some cultural expertise among people who are involved in mediation in all sorts of alternative dispute resolution, but they very often lack the professional expertise. What does it mean to be neutral, etc.? What does it mean? And there is a lack of legal expertise as well. So they culturally they are very well informed, but they don't know the scope and limits within which they can act. So I think there is an urgent need of establishing a system of professional mediation, especially for people who already have a lot of cultural expertise, but need skills in these other areas. So these are my main points. And again, congratulations for your tremendous project.
Thank you very much. And now for our final discussant, Dr. Pilatovsky. Dr. Bartosz Pilatovsky is the founder and president of the board of the Court Watch Poland Foundation, NGO aiming at raising quality and public confidence in Polish justice system, mainly by engaging local volunteers in trial monitoring. Bartosz is a sociologist and has vast experience in research, training, and leadership gained in public as well as private for and non-for-profit organizations. He's been sharing Court Watch's results and methodology on training and conferences in many international contexts, including in the US, Western Balkans, Ukraine, Georgia, and Armenia. I now give the floor to Dr. Pilatovsky.
Thank you, Joshua, and thank you, Livia, for invitation to take part in this important meeting. And I join to the praises you already received for the work you have done. All the team, Livia, congratulations. That's a tremendous work and very important now. Also important now in my country, which is Poland, as we turn from a very unitary in sense of culture country to a multicultural country in the recent years, and especially this year with the vast migration from Ukraine, surely making this demand for cultural expertise even more important. To address those issues you've been asking for, especially milestones, I would agree with my predecessors and point out for the awareness, of course, because this is most important for us to raise the awareness, to raise the knowledge, to raise the demand for cultural expertise where it's needed. So this is obvious, and this can be achieved in Poland by contacting, for example, with the National School for Judges and Prosecutors, because we have a centralized system, both for new forthcoming judges and prosecutors, as well as for those that already are performing these roles. So the school would be a great help to disseminate this information, also to provide trainings that would make prosecutors and judges more aware of this possibility of using cultural expertise. Also associations, especially judicial associations, they also organize trainings, they also organize meetings, disseminate information among their members. These might be also supportive to share this knowledge that you have gathered here. The other point, the other milestone I would like to underscore is implementation. Because in the case of my country, maybe it is the case in other countries, as we have heard from Professor Rohe and also from Judge Wiersinga, we face problem of financial nature. Justice system is always underfinanced. I hear about it all the time, and this is one of the fields where we have negative consequences of this lack of funds. Why? Because if you have not, if you are not paying enough a competitive amount of money to the experts, you won't attract the best of the best from the market to perform this role in the courts. They would avoid it instead of helping the system. Maybe in case of cultural expertise, this is a lesser problem than in other fields, like for example medicine. But still, this is something that should be taken into account. On the other hand, the implementation should take into account the procedural and justice, and also transparency, accountability of the experts, because of the importance for the verdict of what the expert would say. It's a huge deal in Polish, in case of Polish procedures, that what the expert would say is really very influential towards the verdict. So it's really important for the people to be sure that the experts that being appointed are those that have the qualifications and competences, and also that they have the integrity to influence those verdicts. And this is a question how to do it if you don't have an association, for example, that would in general keep the accountability, keep the accountability of the experts. I would like to also to address one other thing. You were mentioning ADRs, so those out of courts solutions where the cultural expertise could be also useful. I would like to point out that we have kind of created a problem by creating this modern state judiciary, which is very professionalized, but also very concentrated on legal formal issues, and also being a reflection of this state, nation state. But in the past, we were solving problems without it. And it's sometimes a good idea to just look in the past and learn from the past, make a step backward and see how those problems were resolved. Poland is now quite a unitary country in sense of culture, but in the past it was very, very multicultural. We had a large Jewish community, Armenian community, Ukrainian, Belarusian community, German community. And all those people were using institution that was present in Poland, in Polish culture, in Polish legal culture, before even those modern state courts. That was compromise courts, which could be called arbitration courts, where the parties were actually choosing their mediators. They were called mediators from Latin, but these were judges, lay judges picked by the parties, serving in just this case to resolve the conflict. And they usually coming from different communities. So someone that was from one community and someone from the other, when they had a conflict, they could find other people that had a lot of trust, public trust in the community, to come to a verdict. They would maybe choose an Obermann, so the one person that would lead the court. But basically, there were solutions in the society, in the culture, to resolve also problem and conflicts arising between those cultures. So maybe we just need to learn from our past, from our rich history, also to introduce solutions that will help us tackle the problems that we face now. Thank you.